We're going to be starting with the Supreme Court ruling that I've got to say really caught me off guard. It's only temporary right now, but the decision was basically made that ICE officers can stop people for the crime of being Hispanic, despite the fact in 1975 the court ruled that if you were a Mexican, police officers couldn't stop you for just suspecting that you were Mexican. So yeah, this is crossing a line, and it is only temporary. But you do wonder why in America you would have 6 Supreme Court justices saying it's okay to stop somebody and search them. Right. And that's not a violation of the United States Constitution or the constitutional rights because they speak Hispanic or because they may have a certain job. So that's where we are.
This is where we stand right now. Let's dig into it. The Supreme Court blocked a lower court ruling that restricted the ability of federal officers to conduct immigration stops in Los Angeles. The High Court's decision puts a hold on a July ruling that said immigration agents could not stop people purely because of their race or ethnicity, because they speak Spanish, or because of their work or the places they congregate. The ruling drew a harsh rebuke from Justice Sonia Sotomayor, the first Hispanic to serve on the court, who wrote in part, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job, rather than stand idly by while our constitutional freedoms are lost. I dissent." She was joined in dissent by the court's 2 other liberal justices. Speaking to NBC's Vaughn Hilliard at the White House, border czar Tom Homan praised the decision and defended ICE actions.
Is racial profiling justified?
There's no racial profiling.
Are you encouraging your agents to racially profile individuals in this country as part of their immigration enforcement efforts?
That's illegal. We're not racial profiling anything.
You're not using race. You're not using race to justify.
I just said we had to establish reasonable suspicion. That's a legal claim.
So can you clarify what that looks like?
There's a myriad of factors. I trust the professionals of the Border Patrol and ICE, all very well trained, to make sure they establish reasonable suspicion to briefly detain and question somebody. And the Supreme Court agreed.
You know, Willie, in her dissent, Justice Sotomayor talked about the indignity of Hispanics having to carry around documentation just to prove that they're Americans or just to prove that they're in this country legally. Think about that for a second. Hispanics now have good reason to have to carry around documentation so they won't be stopped by ICE, and who knows what happens after that. Think about all the horror stories. And as for Brett Kavanaugh, I'm not exactly sure if cable got disconnected in his office over the past 6-9 months. But this is what Justice Kavanaugh said, justifying the stopping of somebody just because they look Hispanic or just because they may speak with an accent. Kavanaugh writes, as for stops of those individuals who are legally in the country, the questioning in those circumstances is typically brief, and those individuals may promptly go free after making clear to the immigration officers that they are U.S. citizens or otherwise legally in the United States. A justice for the Supreme Court saying the burden is on the person for being guilty of being a Hispanic, basically, in the eyes of ICE. And so because they are Hispanic, because they may speak with an accent, they can be stopped now in the United States of America by law enforcement officers and then have to justify it. And I also, let's focus on what Kavanaugh said. He said the stops are typically brief. No problem at all. How many horror stories have we heard of U.S. citizens, of people with green cards, of people here legally being thrown into ICE detention centers, being arrested, being harassed. I mean, can you imagine? Could any of us imagine going to work, being late to a kid's baseball game, being late going to church, trying to get to an appointment on time, trying to pick up kids from childcare, trying to get a grandmother out of a doctor's appointment in time, and being stopped for 20, 30 minutes, an hour and a half because you're Hispanic? That's what this Supreme Court ruled yesterday. Temporarily or not, it's surprising, to say the least, that's an understatement, that 6 justices from the United States Supreme Court would say this sort of racial profiling was protected by the Constitution of the United States, because it's not.
And it blocked that U.S. District Court ruling that was clearly saying, we do not want to live in a country where you can stop people based on their race, their ethnicity, the language they're speaking, or the kind of work they're doing. For example, if you're a day laborer, we're going to stop you and just make sure that we check your papers. This is a dangerous road to go down. Let's bring in NBC News senior Homeland Security correspondent Julia Ainsley, former U.S. attorney and MSNBC contributor Barbara McQuade, and New York Times opinion columnist David French. Good morning to you all. Julia, I'll start with you here at the table with us. What has been the reaction in Los Angeles, in Southern California, and frankly, places across the country where people, Latina women are going to work, as Joe said, taking their kids to school, now stop and think, which way do I go? Are there ICE agents around?
Well, there's certainly people in Boston and Chicago who are worried about this ruling, because we know those are 2 cities that are going to be targeted next by ICE enforcement. And I have to say, Willie, even though this ruling came down from the district in July, since then there were incidents that seemed to violate it. If you think about that Operation Trojan Horse, where the Border Patrol agents jumped out of a Penske rental truck in a Home Depot parking lot in Los Angeles, that seemed like a random profiling sweep. Yet that came after this order. In D.C., I talked to parents who were worried to take their kids to school because 2 or 3 parents in their neighborhood had been arrested just that week. And they were really worried about being stopped for no other reason other than being Hispanic. And so there was already this fear. And now the Supreme Court has said they can go back to those policies. It also, frankly, we have some original reporting now that shows that this is part of a practice where they no longer have to do their homework. They used to have to fill out this form. This has been in place since at least 2007, where they would say the name, the address, the person they were going after, more information. Do they have a criminal history? Are there children in the home? Now they've scrapped that. Under this administration, they no longer need to fill out those forms. They thought it was getting in the way. They thought it was bringing down their arrest numbers. And so what this means now is that they're able to go out to places where they don't know anything about the person that they're stopping. They used to have to get approval from a supervisor. And yes, maybe in the course of an operation, they might encounter someone who is undocumented. But now they can begin an operation without knowing anything about their target. And I think that's really telling about what we've already seen, and especially about these efforts that are about to ramp up.
And leaving it to the discretion of an ICE agent, of someone who looks illegal to them and who they can stop and then question. So, Barbara, Joe just read from the decision here, Justice Sotomayor saying this in the dissent: we should not live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Were you surprised by this ruling from the Supreme Court?
Yes, very much so, because it flies in the face of Supreme Court precedent. Since 1975, racial profiling has been illegal in this country. There's a case there that is a landmark case that is taught in criminal procedure classes, including mine, called United States versus Brignoni-Ponce. And in that case, Border Patrol agents who were conducting roving patrols in Southern California were said to be in violation of the law when they were stopping people based on appearance alone. And so since that time, there has been a ban on racial profiling in immigration enforcement. Now this decision says that they can do it based on appearance alone. That is a shocking change in the way we have always understood the law. The other thing that's troubling about this decision is they don't explain why. How is it that they are making this decision that flies in the face of prior precedent? We don't know, because this is another case on the shadow docket.
Yeah, you know, David French, I always have joked that I've spent my adult life being a political psychiatrist, telling everybody that everything's going to be okay. The subset of that over the past 6 months has been saying, you know, the Supreme Court decision that you just heard about, the headline overstates the case. The lead really overstates the case. Go down 3 or 4 paragraphs and you really figure out what's going on here. It's not as bad as it seems in many cases. In this case, I'm going to leave it to you to be my Supreme Court psychologist and tell me why I shouldn't be deeply disturbed by the fact that even temporarily 6 justices of the United States Supreme Court said it's all right to stop a Hispanic person who may not have a job at a hedge fund and may have an accent because they and their family pursued the American dream and came to this country legally.
Well, I think the court isn't exactly saying that. Essentially what the court is saying, and again, it's absolutely correct to say, well, we don't really know what the court's opinion is here, why it's reaching the conclusion that it's reaching, because it hasn't written fully about it. But from what we can discern, the ruling here is not that there's carte blanche. The ruling is that the injunction is lifted. But here's the subtle nuance here, and that you could still, if you're subjected to a constitutional violation, you still have a remedy. You still have an ability, say, to sue the government. But the problem here is if you zoom back and you look more broadly at Supreme Court precedent in this area, you find that the Supreme Court has actually narrowed the ability to sue the government. So while the court isn't really saying you're free to violate the Constitution, what the court is actually saying is if the government violates the Constitution, you have other remedies other than an injunction, looking at the Kavanaugh opinion, for example. The actual reality is when you zoom back, those other remedies may turn out not to be effective at all. And that's where you, I think, might see a disconnect between the Supreme Court's ruling and the actual facts on the ground.
Well, David, and also the Supreme Court often will say, all right, the lower court, David French, the lower court has made this decision. We're not exactly sure what we're going to do. We're going to send it back down to them for clarification. But often they let the lower court ruling stand, but they will ask for clarification or 1 or 2 points. Here, they stopped it, sent it back, and said, police officers, ICE officers can stop these people all at once. Any idea why they would have chosen that route? Again, a route that seems to fly in the face of a 1975 Supreme Court precedent.
I think if you're going to be looking at it, the court would be saying what we're doing is we're stopping an injunction. We're not creating an atmosphere of constitutional impunity because there still are these damages that you can get if your rights have been violated. And so I think that the court isn't necessarily saying, no, go ahead and violate people's rights. It's saying, no, the administration still has to comply with the law. And if they don't, here's this remedy, versus just carte blanche the administration. And I think that's the nuance here. But the concern that I have is this is not an administration that acts in good faith. And so I think, and the reality on the ground is you're granting an immense permission structure to this administration to violate the law. And the court might still be treating this administration as if it complies in good faith with court rulings and court precedent. And I just think that there's very little evidence that this administration operates in good faith regarding the law at all. It's just not a normal administration.